Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about wiretaps. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Hesi was charged with uttering threats and other offenses as a result of a wiretap authorization that was granted. Even though the wiretap authorization was granted for a different offense than what he ultimately ended up charged with, because the threats and other information came from the wiretap audio, it was used to lay the charge. Mr. Hesi argued that a wiretap authorization is essentially only valid for the offense for which the police are investigating, and any other conversations that reveal other offenses shouldn't be used as part of that wiretap evidence against a person in trial. Mr. Hesi lost. He appealed to the Supreme Court of Canada, who denied leave to the appeal. And this case obviously raises very important issues, not just because wiretaps are one of the most intrusive types of search authorization that are granted, but also because, unlike other types of searches, where generally speaking, people know that they're going on, searches of property, searches of vehicles, that type of thing, a wiretap is police intercepting private conversations. And people say things in private conversations that they might not want other people to know. That's the whole point of wiretaps, is to investigate criminal activity. But just because you have an investigation going on into one type of criminal activity shouldn't expose individuals to having their private conversations on other types of issues used against them in criminal cases. The scope of wiretap authorization is limited in the criminal code, meaning that wiretap authorization can only be granted for certain criminal offenses. So broadening the scope by allowing evidence of criminal offenses that might not otherwise fall within that definition is an important issue that the Supreme Court of Canada should address. And this is particularly so where Parliament has tabled legislation purporting to expand the scope of wiretap authorizations to even more offenses, including offenses related to hate speech. So there are pressing issues that are facing Parliament right now that might benefit from the Supreme Court of Canada's interpretation of statutory authorization for wiretaps. Unfortunately, the Supreme Court of Canada didn't really see the significant implications that this case could have, not just on existing criminal investigations, but also on future ones if more crimes are created should this bill pass. Hopefully another case gets to the Supreme Court of Canada to constrain the intrusive nature of wiretap authorizations, but until that point, this remains the state of the law. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.